just to speak to this group of amendments and to move 10, 11, 30 and 81 my name. And to say, first of all, that in relation to fetal abnormality and inevitable miscarriage, I referred to those earlier, and I do believe that these two items should be, and indeed could be, included in this bill, and could be included within the terms of the Constitution. The group terminations for medical reasons have pleaded with us and with the Oireachtas to deal with this question, this sad and tragic question of fetal abnormality. These are much wanted pregnancies which sadly and unfortunately turn out to be incompatible with life. And this group has asked us, and I'm quoting here, it says, "It's happening every day. Please do not ignore this crisis. We ask you to include provision for termination of pregnancy on grounds of fetal abnormality as part of the forthcoming legislation on abortion in Ireland." And they say that there are approximately 1,480 of these cases every year, where now these women, these couples are forced to travel to Britain to seek terminations. And as they have said themselves, compassion is all very well, but at this stage what these couples need is action, and they need this provision included in the legislation. And I think they've told their own stories and published their own stories, and I think it would be important and instrumental and informative for the Chamber to hear very briefly one of those stories. And it goes like this, and I'm quoting now. It says, "At 22 weeks we went in for our scan. We were shocked when after nearly 2 hours of scanning we were told that our baby was incompatible with life and was going to die. We were further shocked when our consultant told us our options were to continue with the pregnancy or travel to Liverpool. Our baby had no kidneys, brain abnormalities and spina bifida so severe that if it had been the only thing wrong, she would still have died." This is an example of the tragic situation that some couples find themselves in, as many as 1,500 couples every year. I said earlier that I believe, and we believe, that this could be dealt with in this legislation within the terms of the Constitution, and quite a number of legal experts have confirmed this view, and indeed have spoken at the hearings of the committee and have put that view forward quite clearly, and are very strongly of the view that dealing with terminations for this particular condition is compatible with the Constitution. And I think it is important to note as well that the state itself is on record as inviting the European Court in the D versus Ireland case to take that view, to take the view that termination for fetal abnormality is compatible with the Constitution. And just reading from a portion of that, and it says, the Irish state argued that that's D, should have applied in the Irish courts first, because she had reasonable chances of establishing that the Constitution did not apply to a fetus with a lethal anomaly. Although Article 40.33 excludes a liberal abortion regime, a court would not apply it with remorseless logic to such exceptional and tragic circumstances. That was the view of the Irish government, and they invited the court to take that view. And the judgment itself, a section of it which is important, goes as follows, and I'm quoting. It says, "Accordingly, although it was true that Article 40.33 had to be understood as excluding a liberal abortion regime, the courts were nonetheless unlikely to interpret the provision with remorseless logic, particularly when the facts were exceptional. If, therefore, it had been established that there was no realistic prospect of the fetus being born alive, then there was at least a tenable argument which would be seriously considered by the domestic courts, to the effect that the fetus was not an unborn for the purposes of Article 43.3, or that even if it was an unborn, its right to life was not actually engaged, as it had no prospect of life outside the womb. In the absence of a domestic decision, it was impossible to foresee that Article 43.3 clearly excluded an abortion in the applicant's situation in Ireland." I think there is overwhelming evidence that this fetal abnormality can be dealt with in this bill, in line with and compatible with the Constitution. I just want to briefly as well refer in particular to Amendment 11 in relation to inevitable miscarriage. And again, this is one again that I believe and is widely believed to be possible to include in this legislation, and would be compatible with the Constitution. And again, this is the case. This is the case of the sadly of the late Savita Halappanavar. And it's important to recall what the HSE report in just June of this year said in relation to this whole question of inevitable miscarriage. And the report says that concerns about the law impacted on the clinical professional judgment, and it recommended that the Oireachtas consider the law in relation to the management of inevitable miscarriage in the early second trimester. And it says that the clinician's plan for treating Savita was wait and see due to the interpretation of Irish law. The effect of the current situation is, and if inevitable miscarriage is not included in this legislation, the continued effect of Irish law will be that medical conditions due to pregnancy that are not in themselves life-threatening, for example, inevitable miscarriage, must be allowed to continue to become life-threatening in order for a necessary termination of pregnancy to be legal. Now, that is an unsustainable situation. And I believe it should be and it must be included in this legislation.
The next speaker is Deputy Wallace.